Welcome to the latest Evershed Sutherland Legal Insights podcast.
Hello, everyone. Welcome to the latest edition of our Tech Talks podcast. And today I'm really excited to cover an area around AI law that is, well, it's been the talk of the town since since generative AI became such a massive trend, which is the issue of copyright and AI. It's one of the main legal challenges that we grapple with as legal practitioners, and that companies in the AI sphere, whether providers or consumers, are grappling with. And there's a lot of trends to cover, a lot of issues at stake, and sort of industry changes as well. And I have a great panel to talk this through with me. But first, a very quick round of introductions. I'm Nasser Ali Hassaune, partner in Evershed Sutherland based in Dubai, and I'm proud to lead our global AI and TMT teams. Anne?
Hello all, I'm Anne Fort. I'm a partner in our U.S. law firm, Evershed Sutherland, and I have been working in the intellectual property space for over 30 years now, and happy to have the chance to talk about this great, new, and changing area.
David?
Hello, everyone. I'm David Wilkinson, and I lead the IP practice at Evershed here in the UK.
Caroline?
Hi everyone, I'm Caroline Layanaz, a tech partner based in Paris at Evershed Sutherland. My practice covers IP, IT, data protection, and cybersecurity. And in Europe, that means I spend a lot of time on digital regulation, and notably what's bring us together today, AI Act and copyright.
Well, that's brilliant. I'm really looking forward to hear from our panelists today, and I know they all have a really strong track record in this field. I mean, just setting the scene very briefly, I would say the issue of AI and copyright is essentially around, the amazing work done by AI platforms, involves training on materials, scraping data from various sources, and the debate is whether, as these AI platforms gather this data, as they read materials and come up with the answers we all get in a second, in doing so, in the way they train themselves, in the way they have access to these materials, are they infringing the copyright of the stakeholders, whether it's a newspaper, an article, a book, and the like, or a piece of music or a picture, whatever copyrightable subject matter it is. That is the essential question. And to kick us off, I want to start with you, David, to talk about, as these issues take shape and the various, claims and counterclaims and litigation actually takes place around the world. I think one issue that is coming up, and that is a hot topic, I would say, is the issue of jurisdiction. And I understand there's been some developments in case law in the UK in that space.
Yes, that's right, Nasser. One of the cases that we IP lawyers here in the UK, and indeed others around the world, have been watching very closely is Getty Images against Stability AI. And the trial in that case took place in June, July this year, and we're expecting the judgment inside the next couple of months. One of the issues that became very important in the context of that litigation is jurisdiction, and what can happen, what can go wrong if you don't get fundamental points like jurisdiction established. So one of the primary claims being brought by Getty Images related to the alleged copying at the training and development stage by Stability AI. And that's what we call primary infringement, copying. And to bring a copying claim before the English courts, perhaps not surprisingly, you've got to show that there has been copying here in the UK. And that was Getty's contention. They argued that Stability has downloaded and stored data sets at the training and development stage, and that involved the infringing act of copying. That was denied throughout the case by Stability. And in the end, much to the surprise of all the watchers and those listening in on the litigation, the infringement claim relating to copying was dropped partway through the trial. Now, we don't know exactly why that happened, but one might presume that Getty and its lawyers reached the conclusion that the disclosure from Stability and the cross-examination of its witnesses at trial did not raise sufficient evidence of copying here in the UK. And that doesn't mean, of course, that copying at the training and development stage can never be an infringement. Rather, it means that that jurisdictional hurdle has always got to be met, and you've got to show that the infringing act is happening here in this location where the court is situated. And equally, so far as AI developers are concerned, if they want to avoid copyright claims in the UK, well, then they need to ensure that the training and development activities take place somewhere else. So it's really, in some ways, as simple as that. It's a very fundamental point, but it's one that caused huge problems for Getty.
So that's a really fascinating case, David. And actually, yeah, I mean, there's the fundamental legal issues at play here. But if the jurisdiction is not established, I mean, that in a way that sort of changes the whole landscape around in a case and the whole set of issues. So, but turning to the substance and sort of where copyright law is in various of the jurisdictions that we're talking about, and somewhat linked to what you mentioned, David, in terms of the principles involved. How would you? It'll be great to get from you and sort of an overview of the U.S. law as it currently stands on such issues. And there's always the exception around fair use and fair dealing. So I think a quick overview of U.S. law in this regard would be very helpful, Anne.
Of course, what's coming out of the major litigation decisions that we've experienced here in the US is a trend toward finding that the training process amounts to fair use if, and here's the big if, access to the training material was obtained in a legitimate way. So specifically, in the Bartz versus Anthropic case, the trial judge there, the esteemed Judge Alsop, determined that the book databases that everyone admitted were pirated, right? That was not permissible under US copyright law. To copy, to train from them was not permitted. But the training process, if access was legitimate, was fair use. And so rather than litigate that all out to the very end and have appellate court decisions on these issues, Anthropic and the class of plaintiffs reached a settlement that would compensate at least some of the authors of the millions of works that were in those two pirated databases. So that's sort of the hot off the press, what's going on in US.
Very interesting. So in this case, I think in a way, Anne, it's fair to say it became an issue of quite traditional copyright principles. The base of the materials in question were pirated. So in that sense, that sort of provided a strong basis for the parties to reach a settlement. David, I mean, if I could go back to you, would you say on the laws of England and copyright law in England, is it a similar situation, or the judges would be grappling with similar principles around fair use?
Well, unlike the United States, the United Kingdom does not have a defense of fair use. Here we have really quite specific and fact-sensitive exceptions around fair dealing, and they cover things like fair dealing for the purposes of criticism and review, or research and private study, news reporting, and so on. So because they are so fact-specific, I think it's unlikely that in a typical AI training situation, those type of exceptions are really going to assist the developer. And indeed, it may well have been part of the reasoning of Getty Images in bringing their claim in the UK, precisely because there was no broad fair use defense in this jurisdiction. As we've seen, they ran into problems on other issues around jurisdiction. But so that's my thought really as regards the UK.
That's very, very interesting, David. Thank you very much. Moving on to you, Caroline, it'd be good to look into situation in France, which of course means the situation in the EU and around such issues. And there's of course a lot of talk about the EU exception around data mining that was legislated a while ago. So it'll be good to get your view on that from a EU and French perspective.
Yes, thank you, Nasser. So in Europe, obviously, the same tension between copyright and AI exists. When it comes to regulation, the EU usually moves first, and with AI, that's exactly what happened. But the way Europe has responded is quite different because we need to go back, you're right, to 2019 when Europe passed the EU Copyright Directive. So at that time, nobody was talking about ChatGPT and GenAI. The debate was about this exception, text and data mining for commercial use. And there was a small rule hidden in that directive, which said that copyright holder could reserve their rights with respect to text and data mining. So in practice, that meant that a publisher or creator could say in license terms, my works cannot be mined. And so in 2019, it really looked like a technical, almost invisible point. But today, with AI models trained on billions of work, that small rule has become the key legal tool for creators to say, don't use my content to train your model. And now if we move forward to 2025, so the EU AI Act has arrived, and this regulation takes that small opt-out rule from 2019 and makes it a real obligation for big AI model. So basically, if you want to place a model on the EU market, you must have a copyright policy, respect those opt-outs from creators, and publish a summary of the data you use for training. And there is an additional shift to all of that, which is quite important because copyright law is normally territorial, so it usually stops at the border. But the EU AI Act says in one recital, it doesn't matter where you trained your model. If you sell it in Europe, you must follow the EU's copyright rules. So that's a big shift in the EU landscape because it makes the AI Act extraterritorial, and all these requirements around transparency, compliance with opt-out of creators, it just needs to be embraced by the AI provider when dealing with their models.
Yeah, very, very interesting. I mean, this issue, looking at it, I mean, you mentioned something, Caroline, which I actually believe in, that, you know, sort of when they were looking at the data mining, opt-out, etc., that they didn't have the scale of what's happening on the AI front in mind. And I think that's in many ways how I see it, that this generative AI revolution, if we can call it that, has sort of resulted in a business model, or in a way that data is gathered, trained on, you know, used to create new outputs, was not, in my view, envisaged by the Berne Convention or other copyright treaties and the local legislations. That in a way, as developers and creators grapple with these issues, my sense is that we must be heading towards new laws and new understandings around copyright law, because we're dealing with something that I think was not envisaged at the time these laws were made in many cases, or the main treaties in that place. Would anyone like to comment on that, or before we go to the next subject?
Well, I'll pick that one up, Nasser. I think something that's happening here in the United States indicates that either we're moving to needing an official change in the law to accommodate the growth of AI, or everyone is just making their own rules via contract and moving on. When one of the events here in the US that I think demonstrates this fact is of course, well, the settlement of the Anthropic, the Bartz versus Anthropic case is an example of that. Rather than wait to see what happened, Anthropic just said, okay, well, let's just bring this one to an end. And we've got, dozens of other licenses and training contracts and so forth that have been entered into between suppliers of content and owners of large language models so that their processes can proceed without needing to wait for the courts or the Congress to solve this problem.
Yeah, very, very interesting. So yeah, that's because if there's uncertainty, I think that the developers and the creators are, in a way, incentivized to sort of reach their own arrangements, and I feel we probably will come in jurisdiction by jurisdiction probably to a moment of greater clarity by the legislator or in case law. David, any sense of? I mean, I think you gave a hint earlier, but any sense of where you see case law going in this regard?
Well,
in the UK.
Here in the UK, as I mentioned, we do not have a specific exception or a general fair use exception, nor indeed at the moment do we have a text and data mining exception as they have in the EU. So the UK could be a fertile ground for claims in this area. However, the jurisdictional point, which I mentioned earlier, is a very real one. And
yes,
in practice, so far as I'm aware, a great many AI systems are trained and developed in the United States. To bring a claim in the UK, you've got to show copying here in the UK, at least so far as primary infringement is concerned. But that may change over time. We had yesterday an announcement of tens of billions of pounds of investment by the major tech companies into AI technology here in the UK. So that would indicate that we are going to have AI development here in future, but we shall see.
I'd like to comment on the jurisdiction point in thinking about where training actually takes place, other than being, suing the developers where their headquarters are located. The facts of where training actually takes place could be quite complicated. Most tech work is highly distributed, and I see no reason to believe that this work too wouldn't be highly distributed, raising questions of where training, close quote, actually takes place when your workforce might be scattered over the globe.
Thank you very much, Anne, for that. I mean, one question, moving on to a related topic, of course, one question I get wherever I speak at the sessions, and you get a lot of sort of creators actually and writers and come up and ask this question, sort of copyright ownership of output that's generated with the assistance of AI. That's a very hot topic across the world, and obviously a matter of local law around copyright. But David, any views on that and sort of developments in that space?
Well, here in the UK, Nasser, we're one of the very few countries which has copyright owners provisions that specifically deal with computer-generated works. The others, as far as I know, are New Zealand, Ireland, India, and Hong Kong. So they're all English common law countries. Now, that may indeed look very far-sighted in the part of our legislators, because our Copyright Act dates back to 1988, when AI wasn't even a twinkle in anyone's eye. So where we're at with it in the UK is that where a work is computer generated, the author is the person by whom the arrangements necessary for the creation of the work are undertaken. So in the context of AI, that's likely to be the person who's responsible for running the AI program, if I can put it that way. It gets more complicated where the work is AI assisted rather than exclusively written by AI. And so in situations where there's some kind of human creativity involved, it might be the case that the human takes all, and they're the sole author and owner of copyright. Or alternatively, it could even be a work of joint authorship, partly the human and partly the person who made the arrangements necessary to run the AI program.
Yeah, and today it's fascinating. Our discussion today is on copyright. I think when it comes to patent, I understand around the world there's been so many cases that essentially, in most part, have concluded that if patent is generated by an AI module or an AI platform, the ownership has to be a human. It can't be the AI.
That's right. There's got to be a human inventor.
Exactly.
And in the
exactly.
US, our copyright law is in the same vein.
Mm-hmm.
So the Copyright Office has officially stated its policy that if the work is generated by an AI tool in response to a human prompt, the generated work is not copyrightable. It is because it was not the work of a human being.
Right.
If the result mixes the original work of a human being and the generated work of an AI tool, the human being generated original content can be protected by copyright.
Very interesting. Carolyn, any views on that?
No, basically it's the same in the EU. Only humans can be authors, sorry.
Right.
And I think that's the case of most jurisdictions, which now have a human authorship requirement. After, we are only at the beginning, so cannot say what will be the case in like 10 years from now. So we need to keep track of the evolution and how the law adapt to new technologies and new scenarios of creation.
Well, now it's on to my last question, where I ask our great panelists to be, oracles of the future and to sort of give us their gut feeling of where we're headed here. I mentioned before that I think there is an argument that there is greater need for legislative clarity here around those issues, as copyright laws in the past may not have envisaged this type of development. So yeah, if I can go one by one and see where they see the future in that space. So, David?
So here in the UK, our government ran a consultation exercise in relation to copyright and AI, which opened last December and closed at the end of February this year. And the stated aim of that was to consult on legal options for eliminating exactly the kind of uncertainty that we've been talking about today around copyright and training and development of AI systems. The government did not simply sit on the fence. They said that their preferred approach would be to adopt a text and data mining exception, quite similar to the kind that has been adopted in the EU and subject to a potential opt-out by copyright owners who did not want to participate. It's fair to say the consultation generated a lot of debate, quite a bit of controversy. You had AI developers on the one hand who were arguing for a wide exception, and then content owners or creators, including Sir Paul McCartney, Elton John, and other luminaries who were extremely vocal in their opposition. So at the moment, we're still waiting to see which way the government jumps, but this is as much a political and economic issue as it is a legal one. And I mentioned that there was an announcement yesterday of very significant investment into AI development in the UK, and I can't help wondering if that might give us a clue as to the direction of travel, but we shall see.
Well, yeah, I mean, actually, David, it's fair to say it's not common for a sort of legal consultation about an IP law to become global news. I think it was the #1 news item at one point around the world, as you said, with Elton John and others engaged. It's obviously a very emotive subject for everybody involved. It's a big issue and could affect a great deal in terms of how this evolves, how the creative industries evolve, and also how the innovation around AI evolves. Carolyn, it's fair to say the EU is almost always the first to legislate. So they got going with the EU AI Act, and around the copyright issues, there's been sort of some activity. Where do you see this heading? Do you envisage further directives or laws in the near future, or do you think it'll be a wait and see by the EU at this stage?
It's quite complicated to say because on the one hand, you have the EU AI Act, which entered into force last year, but there is a lot of work now around secondary instruments, a lot of around transparency requirements. So there is a code of practice which was published. There is a training data summary template, a lot of tools which are supposed to help to improve transparency around training of data models. And every one of these texts is the result of intense negotiation between the party and the different stakeholders. And on the other hand, Brussels just launched a consultation under the digital omnibus to simplify EU regulation, among which is the EU AI Act. So the idea is to reduce the burdens, provide predictability, and addressing implementation issues before the main obligation even takes place. So there is really a mix between two scenarios. And I think in Europe, one last point is, in addition to regulation, there is the question of the enforcement, because we know from other digital regulation like DSA, DMA, that enforcement in Europe is complex. And even if Europe decide to sanction at some point, applying the sanction will not be easy because of the geopolitical context, and with Washington now pushing hard against new AI rules, especially from Europe. So it would be interesting to see in the next couple of months, couple of years, how everything will be managed together.
Well, you mentioned Washington, so I'm leaving the easiest question to Anne. How do you see it going in the US? And I mean, it's very complicated in the US between the federal and the state level as well. So it's probably hard for you to predict.
My prediction is that everyone will continue to say that the growth of AI is essential to economic growth. And then after that, no one will agree about very much. The perspective in the United States right now is, on a federal level, it is very difficult to reach the kinds of consensus that would be required to have any legislative action whatsoever on this point or on any other point. And so when we look to policy making, there's a moratorium, allegedly, that we would like to have on the states making any sort of regulation of AI. And whether even that remains live is in question right now. Senator Cruz yesterday said, yes, we're still going to impose that. Other people say, no, we're not going to impose that. And so where does that leave us? Well, it leaves us where we go a lot of times, to mass tort style litigation, to impose massive damages on actors in the economic field to change their behavior. And that then can lead to negotiated resolutions like the music streaming model that seems to be working, maybe not to the satisfaction of everyone who's a stakeholder in it, but at least there is process. So I'm predicting that that kind of process to cover the generation of new content is a possibility.
Thank you very much to all our panelists. I think we can all agree it's a very exciting area of the law, and and pick on Anne's point at the end, it's very hard to predict the direction of travel, but for us legal practitioners, it's an area we must continue watching and monitoring very closely. So massive thanks to Caroline, Anne, and David for a great discussion. I enjoyed it tremendously, and I'm sure our listeners will too. I hope you enjoyed this latest episode of Tech Talks, and please look out for the next one, where we'll be covering yet another exciting topic of law and technology. Thank you.
Thank you for listening to the Evershed Sutherland Legal Insights podcast.